Welcome to The Explainer. Today, we're unpacking a really fascinating dilemma right at the heart of India's legal system. Think about it. How do you strike that perfect balance between the absolute need to protect vulnerable groups from harm and the equally critical need to prevent those very protective laws from being misused? Well, let's dive right in and find out. So, this brings us to the fundamental question, right? How exactly does the justice system balance protecting true victims with preventing false arrests? Because at its core, this is really the story of a law that was designed to be a shield and the ongoing, sometimes messy struggle to make sure it doesn't accidentally turn into a weapon. To make sense of all this, we've broken this explainer down into 4 quick chapters. First, the dowry law dilemma. Then, we'll look at the Arnesh Kumar guidelines. Next, navigating the legal maze. And finally, we'll zoom out to look at the broader right to liberty. All right, starting us off with Section 1, the dowry law dilemma. Okay, so the absolute foundation of this whole discussion is Section 498A of the Indian Penal Code. Now, this was enacted back in 1983 alongside laws concerning dowry deaths. And look, at the time, it was an absolutely urgent and necessary response to combat a rising wave of domestic violence and atrocities against married women. It made cruelty or harassment for dowry by a husband or his relatives a cognizable and non-bailable offense. What does that actually mean in everyday terms? Well, it meant police could literally arrest someone without a warrant, and bail not a guaranteed right. It was an exceptionally strict law, and it was designed that way on purpose to act as a massive deterrent. But as you'll see, over the decades, a pretty stark contrast started to emerge. While it was intended as this crucial protective shield for women facing genuine, horrific cruelty, the Supreme Court actually began to notice a very different reality on the ground. Because the law was so incredibly strict and non-bailable, it was sometimes being weaponized. Disgruntled individuals were using it to harass innocent people, leading to these sudden, devastating arrests based on complaints that didn't even have substantial verified evidence backing them up. And the data that finally forced the judiciary to step in? Honestly, it's staggering. Back in 2012, nearly 200,000 people were arrested in dowry-related cases. 200,000. But the conviction rate? A shockingly low 15%. This objective data proved without a doubt that a massive number of these arrests were just entirely mechanical or completely unnecessary. The courts literally had no choice but to address this glaring imbalance. So, to put the brakes on these mechanical arrests, higher courts actually had to step in and explicitly define what legally constitutes cruelty. And some of these clarifications are almost surprising to think about. For example, the Bombay High Court had to officially rule that, no, asking a wife to do household chores does not legally equate to treating her like a servant. The Supreme Court had to clarify that a mother-in-law simply keeping jewelry in a safe, not harassment. Basically, the courts laid down the law saying that vague, generalized allegations without any specific dates or actual incidents, those just aren't going to cut it to sustain a charge anymore. Which brings us to Section 2, the Arnesh Kumar Guidelines. Now, 2014 is when things really shifted. The Arnesh Kumar case was a total game changer. The Supreme Court laid down a massive ruling, stating arrests should be an exception in cases where the punishment is less than 7 years of imprisonment. And since Section 490A carries a 3-year maximum penalty, boom, automatic arrests for it were suddenly and definitively prohibited. And here's the kicker. The Supreme Court didn't just hand out friendly advice. They attached some incredibly severe consequences. Today, police absolutely must follow a strict checklist under Section 41 of the Criminal Procedure Code. If an officer arrests someone without written justification, meaning they have to actively prove the arrest prevents further offenses or evidence tampering, they are in big trouble. We're talking departmental action, contempt of court, even potential jail time. And it goes all the way up. Even magistrates face disciplinary action if they just blindly authorize detentions without reviewing the underlying reasoning. It's a huge accountability shift. All right, moving on to Section 3, navigating the legal maze. Let's get practical for a second. For a genuine victim of domestic violence, the legal system actually provides a really robust pathway to protection. The first actionable step, gather evidence. This means medical records if there's physical abuse, and digital evidence like texts or emails. Next, victims should immediately contact the Women's Helpline, numbers like 1091 or 181 for round-the-clock support. From there, it's about filing an FIR at the local police station. And hey, if the police drag their feet, the victim has the absolute right to escalate the whole thing to the state or National Women's Commission, or just petition the court directly. But conversely, what if a family is being targeted maliciously? Well, the very first step is absolutely crucial. Secure immediate legal counsel to prevent an arbitrary arrest. The biggest tool in the toolbox here is filing for anticipatory bail under Section 438 of the CRIPPC. It's essentially pre-arrest legal protection. At the same time, the accused needs to meticulously save all digital communications, financial records, and witness testimonies that contradict the fake claims. And finally, because at the end of the day these are usually matrimonial disputes, exploring structured, court-appointed mediation is often the smartest, most effective way to resolve the underlying civil issues. Let's zoom out now for Section 4, the broader right to liberty. Ultimately, this whole discussion boils down to one super famous legal maxim: bail is the rule, jail is the exception. You've probably heard it before. This principle is deeply, deeply tied to Article 21 of the Indian Constitution, which outright guarantees your fundamental right to personal liberty. And the Supreme Court just passionately reiterated this in a sweeping recent judgment known as the Satinder Kumar Antal case. They made it crystal clear: personal liberty should never, ever be stripped away before a trial unless it is absolutely necessary. To make sure this was actually applied evenly across the board, the Antal case completely categorized offenses to streamline how bail works. So under Category A, which is offenses punishable by 7 years or less, courts are supposed to issue ordinary summons, not physical arrests, as long as the accused is cooperating. Categories B and D, those cover more serious and economic offenses, and they're decided on their individual merits when the person appears in court. And then you have Category C, which is for special, super strict acts involving things like terrorism or money laundering, where obviously much higher thresholds apply. Now, for those Category A offenses we just talked about, courts are now strictly mandated to follow a graduated timeline. Why? To ensure cooperative folks aren't needlessly thrown behind bars. Step 1 is simply sending an ordinary summons, usually in the mail or through a lawyer. If the accused ignores that, well, then Step 2 escalates to a bailable warrant. It is only at Step 3, if the person continues to actively dodge the law, that a magistrate can actually issue a non-bailable warrant. Liberty is paramount here. Physical custody is literally the absolute last resort. And what's amazing is we're actually seeing these judicial guidelines getting hard-coded into the newest laws. Specifically Section 35 of the BNSS. Under this new law, a formal notice of appearance totally replaces arrest for cases punishable by less than 7 years. Any actual arrests, they have to be heavily justified in writing. Plus, it provides this incredible new shield for the elderly. Arresting any citizen over the age of 60 for an offense carrying less than 3 years now requires prior written approval from a high-ranking officer. We're talking at least a deputy superintendent of police. That is a massive shift. So watching this evolution from really strict, non-bailable law back in 1983 to the highly nuanced, liberty-focused guidelines we have today, it really reveals a legal system that is constantly striving for equilibrium, which leaves us with a pretty big question to ponder. How can society continue to evolve its laws to perfectly protect the vulnerable without sacrificing the fundamental liberty of the innocent? It's a tricky balancing act, one that definitely requires constant vigilance, empathy, and a profound respect for the Constitution. Thank you so much for joining me on this explainer. I really hope the structured look at the law, the guidelines, and the absolute importance of civil liberties has given you a much clearer understanding of what is honestly a very complex topic. Keep asking questions, definitely keep exploring your legal rights, and we will see you next time.